we could be seeing potentially millions or billions of dollars of copyright statutory damages. Deepfakes online are primarily used for the generation of pornography. If this ends up going to trial and the court finds that there are millions and millions of pirated works that were all copyrighted, that's a huge amount of damages. Elon Musk asserted that OpenAI had achieved AGI on the basis of some statements of OpenAI engineers. If you're downloading things that you didn't purchase that are copyrighted, then you're liable for that. This idea that we're going to have AI lawyers, it won't happen. Hi, I'm Christa Laser, and I'm a professor of intellectual property law at Cleveland State University College of Law. I'm also the director of the Intellectual Property and Entrepreneurship Center, which is newly formed there. I have a YouTube channel and a website at christalaser.com where I post topics related to intellectual property law and innovation, including AI, blockchain, and biopharmaceuticals as well.
All right, Christa, thank you so much for being here today. We're going to be talking about some very interesting, very hotly debated topics around kind of the intersection of AI and copyright law. You know, there's a lot of controversy and I think also a lot of confusion and misunderstanding about where everything is heading. So to get some clarity and some understanding about how this, you know, how the law works in conjunction with copyright and that stuff, I think this is going to be incredibly illuminating for a lot of people. So I guess my first question, you know, we're going to be talking about Bart's versus Anthropic, which was a pretty big case that I think illuminated how U.S. law sees a lot of this stuff. But before we even jump in there, I think there's a lot of confusion about what different words mean and don't mean exactly. I know a lot of publications often will say something like these AI models are trained on copyrighted data. So for example, you know, when we're training these AI models, we will use textbooks and books and the internet at large to form that kind of base model, that base layer. And the more good quality writing it has, the better it's able to understand how we talk, how we write, etc. It's very important for that kind of base layer. And on top of that, we can train, you know, with reinforcement learning, various whatever coding, math and stuff like that. But the base layer, just understanding is very important. And of course, they're going to use books and textbooks. And of course, books and textbooks are copyrighted. So when people say, you know, these AI models are trained on copyrighted data, that implies that these AI models are breaking the copyright law somehow. I think a lot of people kind of take it to mean that, but that's really not correct. It's more about fair use. That's my understanding. So maybe you can just kind of enlighten us about what those words mean or don't mean and kind of like how we should be looking at it.
Yeah, it's true that AI models are generally trained on copyrighted data, but that could be done lawfully or unlawfully depending on the circumstances. So many AI models choose to use copyrighted data like books and artwork in order to train their models because copyrighted data often is exactly the kind of creative expression that is useful for generating outputs that are going to exhibit some amount of intrigue or interest. It's going to be much better writing when you can train it on high quality underlying works. And so books are a prime target for that initial training. And as we saw in many of the lawsuits, most of these AI companies did use books as the center of their initial training for these AI models. Now, as we'll get into when we discuss the cases in more detail, some of those AI companies obtained copyrighted works lawfully. So, for example, by purchasing copies, and many of them obtained copyrighted works unlawfully, such as by downloading them from torrent websites. And there are differences of opinions among the cases that have come out so far as to whether engaging in training using copyrighted content that wasn't lawfully obtained is in fact unlawful or not when you're using it for AI training. Some courts say that that initial fruit of the poisonous tree is problematic, and some courts say that once you are using that for the purpose of AI training, if that AI training is a fair use and doesn't infringe copyright or it's a defense to copyright infringement, then that underlying use of pirated material is likewise not unlawful. I think that we'll see courts continue to be divided on that topic. It's a hotly contested issue.
Oh, I bet. And how should people be thinking about fair use? So my understanding, there's like 4 different sort of checks to understand if something is fair use or not. And that's like a lot of what the lawsuit went into. Can you help us understand that a little bit?
Yeah, there's 4 factors that go into the copyright fair use analysis. So once you've determined that something is an infringement of copyright, meaning does it reproduce something that is copyrighted, or does it create a derivative from something that's copyrighted, or did it use that work for the purpose of creating an additional work? So usually copies are made in that process. So for most AI models, they maintain a library of their initial training materials. And so that's the initial copying that would constitute copyright infringement. And then the person who's being sued for copyright infringement can come back and raise fair use as a defense. Fair use is designed for circumstances where the use of the copyrighted works don't harm the copyright holder as much as the public benefits. And there's a statute that sets out 4 factors for determining whether something constitutes fair use. One of the first factors is the purpose and character of the use. And a big question there is this a commercial use or a nonprofit or educational use? Commercial uses are less likely to constitute fair use. But again, all of these are factors and not be-all, end-all. Another consideration for that first factor of the purpose and character of the use is whether it's transformative. So this is the thing that comes up a lot in these AI training cases. Courts have said that because AI models are fundamentally and in extreme ways different from the original purpose of reading a book, for example, training an AI model or even creating outputs from an AI system fundamentally give you a different experience and have a different purpose. And so courts say that's transformative. And when you have this transformative use, that initial factor favors a finding of fair use and therefore defense to copyright infringement. There are a few other factors that are also important. So, for example, whether the nature of the work that's being infringed is one, although this one almost always weighs against a finding of fair use. This is something like, is the work that's being infringed a novel or something creative? Or is it something that's really on the cusp, like a phone book, or something that doesn't have a strong entitlement to copyright protections, that isn't strongly expressive? For almost all works that are being sued over, this is a factor that weighs against fair use because most works that are being sued over are creative works that are clearly entitled to extensive copyright protection, like a novel. Then you have the amount and substantiality of the use. What this means is how much of the copyrighted work is being used in the infringement. So the classic example might be if you have a YouTube channel and you're taking a clip from some other YouTube channel and you take 30 seconds of another person's YouTube clip in order to educate your audience on what that clip was about for the purpose of you being able to talk about it. That's a very small amount of a clip to use, and it's central to your purpose of commenting on and criticizing or whatever it is that you're doing with the original clip. So that amount and substantiality will favor fair use if you take only as much of that original as is necessary to perform what it is that you're trying to do. So if you're making commentary on a clip and you only use 30 seconds or a few seconds of the clip, that's probably fine as fair use goes. Although all of this is on a case-by-case basis, and a small amount of use can still be substantial if the clip was only a few seconds. In the context of AI, this amount and substantiality question is really difficult because oftentimes the AI ingests the entirety of the work. So this would be like taking in the entire hour-long YouTube video, right?
Right.
Or it takes in the entire novel. And if you're doing that, you'd think, well, this is a factor that probably should weigh against fair use because we're using the entirety of the copyrighted work. But the cases that have come out so far, and we'll see if other cases differ when new ones come out, but the cases that have come out so far have said that because AI models must be trained on millions and millions of works, and it's necessary to have the full work for context, that in those situations, the amount and substantiality of the use factor favors fair use, even though you use the entire novel. So they're looking more at how it's being used, that it's necessary to look at the entirety of the book and include millions and millions of books in order to make an AI model. And then the last factor is one that courts differ on how important it is. We'll get into this when we talk about the cases, but the Meta case, for example, the court said that this factor on the impact of the infringement on the marketplace for the original work, that this factor is critically important. And that Meta case found that most AI training is going to not be fair use because it results in flooding the marketplace with AI-generated works that are going to compete with the originals. And so the Meta case said that in every other case except the one that they decided, because they ultimately found in favor of Meta, they said in almost every other case, we would likely see an impact on the market effect. And so in that case, it won't be fair use. That's a bit of a stretch. This idea, it's called a market delusion theory, this idea that new works are going to come in and outcompete the original works, even though they're not the same. Traditionally, this factor considered whether the infringement is going to result in direct competition for the exact same work. And it's very different to look at it from a perspective of completely different works competing in the same marketplace.
Yeah. So where would that be? Where would that happen other than these large language models? Is there an example of, so I can kind of get my head around this?
It's a brand new theory.
Okay.
So this Meta case is one of the first cases where a court has articulated this market delusion theory of the factor for market analysis for fair use. Because it's a brand new theory, that was part of the reason why it was very difficult for the plaintiffs in the Meta case to establish that factor favored them, because the plaintiffs had no idea that the court was even going to use that market delusion theory until it got the opinion back. So without looking at the court's opinion saying that this market delusion was an important theory, the plaintiffs just didn't enter in any evidence of that. They could have had an expert testify to that, but they didn't do so. And so it's a bit of a chicken and the egg problem. Without knowing that theory was in play, it's very difficult to present evidence in support of that theory.
Yeah, and we're still arguing over things like the invisible hand, so it feels like that'll be a really tough one. I'm sort of curious, like, how does what you're seeing play out with large language models versus the same situations if they were done by humans? So if there was a person, for example, that broke into someone else's house and I guess read a creative work that they didn't own and then went out and made a blog about what happened, and they were, definitely breaking the law when they broke into the house to learn it, would that rights be owned by the original people that they learned from? Or because it's a human brain, does it become more free to what came out of it?
That's a great question. And with the case law around human actions, we have a lot more established precedent than we do, obviously, in the case of AI training. So in the case of the human who breaks into a library, reads some information, and then comes out and makes a piece of artwork that's infringing, there's a few steps along the way that would potentially be unlawful. So number one, you would have that action for breaking into the house. Now, reading somebody's book is not unlawful. So just picking up a book and reading it, not unlawful. If you have lawful access to it, but breaking into the house is going to be a violation of law. Similarly, if you were to download a pirated library and read it, that action of downloading the pirated material would be unlawful because you're creating a copy of a copyrighted work without authorization from the original copyright holder, which is one of the types of actions that constitutes an infringement of copyright law. Next, the question would be, what are you doing with the material? So under the theory of the Meta case, where they take this approach with pirated material, saying that if you use pirated material, it's no problem as long as the end use that you're using it for is fair use, if you're using it for training. So likewise, you could think that if that were applied to a human who downloads pirated material and then uses it for a purpose of fair use, like creating an entirely new work that's not similar to the other works that they read, then that's not going to be a violation of copyright law under the meta-analysis, under the Kadri versus Meta case. But that's a very different theory. That's very different from what we've seen for human uses. For humans, generally, if you download pirated content, you download pirated content, and that's unlawful, right? But then let's get to the next question, the separate violation. And this is how the Bartz versus Anthropic case treats it, as separate violations. The pirating is one problem that we need to address, and the Bartz versus Anthropic case says pirating is unlawful. You have to pay for that. And then we have a second potential cause of action for what you do with it. And with a human, if you, let's say, instead of breaking and entering or downloading pirated content, you went to the library and you spent a year reading everything in the library, and then you create some new work. What the court would do is first ask, is there a copyright infringement? If you make something that is substantially similar to or identical to something that you've read, that is a copyright infringement. And the court has a bunch of factors and considerations for whether something is going to be substantially similar. You may have experts come and say how similar things are. This is where you see in music cases where you've got some expert analyzing each note to see how similar they are. And if it's substantially similar, it's going to be an infringement. If you go out and publish or sell whatever it is that you're making, that's going to be an infringement. And it probably doesn't constitute fair use because you're creating something that is often commercial in nature or generates some benefit for you that isn't really a public benefit. You're not creating the work for the purposes of criticism or commentary on the original underlying work. In that situation, you're not going to get the benefit of the fair use defense. And the court's just going to say, look, you made something substantially similar to something you read. The end, that's copyright infringement. When it comes to AI, courts are finding differently. We see in the Bartz versus Anthropic case that the court says it's fundamentally transformative to create an AI system. And so the court's saying that that's somehow different from what a human is doing. And it was important in that case, though, that nobody alleged that what was being output by the AI was substantially similar to any input. And in fact, they had guardrails in place in order to prevent the outputs from being the same as or substantially similar to the inputs that went into the system. This was critical for avoiding that problem that you might see with a human that comes out and makes something similar.
So you said that the courts basically said that what AI models are doing are different from what humans are doing. Can you explain that a little bit?
Yeah, so the courts are saying that the AI models are transforming the original purpose of the work. Instead of just reading a book to make a book that's similar to the previous book, AI models are reading many books to create a system that fundamentally transforms our lives and does something different than a single book does. So they're saying this is very different. Go ahead.
Isn't that kind of like what humans do? I mean, you go to school, you read a bunch of books, and then you're able to produce your own kind of novel content. That's not what they mean, though, because so they're saying it is.
Yeah.
Yeah, just to build on that.
Go ahead.
There's also, a human has the choice to make something that's a really close direct copy or something that's extremely different and only has a hint of the original work. There's a whole range. And in this case, we're talking about an LLM that can be prompted in ways to do one or the other. So it's not like in all cases, it's going to be copyright like looking, but sometimes it might be very similar to what it digested. If the user prompts it, like, hey, give me a very close approximation of this book, then it's going to look a lot closer.
And fundamentally, you're right. If you were to take the example of a human who is not making anything substantially similar to what they read, that's not going to be viewed as a copyright infringement. We wouldn't even need to get to the fair use analysis because humans are not considered to be making a copy of the works when they read it. When you read a book, you don't download a copy into your brain. Right. And so you don't have that underlying act of infringement that the AIs are engaged in. Right. There's some debate over whether AIs actually do make a copy. But in these cases, there are situations where there was a library where they admitted that there were copies of the underlying training data. So humans don't make a copy of what they read in their brain unless you have a very good photographic memory. And even then, you probably won't get the whole book in your head, right? My mom had a side note. My mom had a photographic memory. And when she was in school, she once got in trouble for plagiarism because before she went into a closed book exam, she used her photographic memory to memorize the section of the book that was relevant to the exam and then wrote the answers verbatim from the book. From her memory, and the teacher said, "No, that's plagiarism. You can't do that." And she says, "I didn't copy it from the book. I copied it from my memory."
But in a weird way, even if she did get it from her brain, it still kind of feels like she cheated to me. Like I know she didn't look over at someone else's page, but the point is to synthesize the question and understand it in context. And she learned it. That's fascinating.
So that's the same thing that they're saying is happening for these AIs, that you're basically having a perfect copy that gets made in order to generate the final outputs. And these cases would be coming out very differently in situations where the plaintiff is alleging that the AI system is generating outputs that are verbatim from the inputs. So in the New York Times case, for example, against OpenAI, that's one of the allegations that is going to be very important for the outcome of that case.
Yeah, I read what they submitted as kind of proof of what was happening. There's something a little bit weird there. I made a video about it, and then later, actually, OpenAI came out and said that it's not what it seems. So it's going to be very interesting to see, because the thing is like how it's structured. The outputs are structured. There's like an introductory paragraph, the actual response, and then kind of a summary. And based on the summary, you can tell how the prompt was structured, and they removed all the last paragraphs. So I'm like, oh man, like that would have told us a lot about how they were able to get the model from, to output that result, which is interesting because Anthropic is saying that they put in guardrails that prevent specifically the outputs from being the same as whatever the inputs were for the training data, which is brilliant. I mean, it seems like, because that would definitely take care of that issue. But I want to just dig deep a little bit more into what it means to copy something. Because, for example, like you said, humans don't copy it. They read it, and then they're able to recall it. Whereas with the training of the models aren't copying the information, but in order to have the data to train the model, you do need to copy it on some server and then use that to train the model. Do you know if Google, is that the defense they use? Because they crawl the entire web with their little crawl bots, and but they never copy the web pages. They sort of like just kind of like distill them to the number of links or whatever. So they kind of have a mathematical representation of the website, but they don't copy it. Is that what allows them to do that?
Yeah, there's a lot of debate, and that would be something that needs to come up in fact discovery in all of these cases. But most of the initial lawsuits are being brought against companies that have stated that they have some sort of library, or that they made copies or downloaded copies of these books or the other data that they're using for training. Whereas there's other AI systems that are swearing up and down that they don't make copies of the material for purposes of ingesting into the AI, that they tokenize it first in order to then use it for purposes of training the AI.
That's exactly where I was wondering if there's a way to get that training data without copying it, because I don't think you need the exact copy. There's probably some way to, tokenize it, or I don't know, have like the crawl bots crawl the web, maybe like just never copying it to. So so I'd be curious to know, because there might be some simple shortcut around it.
Although you'd think that even depending on how you're operating, even if you're crawling the web, wouldn't you make a copy when you have a cache or something like that? I mean, I think this is all really fact intensive. And there's going to be experts that talk about exactly how the technology works for those particular companies. But there's a reason why these initial lawsuits are against companies that have admitted to maintaining copies of their training materials.
Yeah. And what did you think about the fact that, so there's two big lawsuits, the one involving Meta and the one involving Anthropic. And both of them are using pirated books or whatever pirated material in order to train their models on, which is, of course, we understand that to be illegal, breaking copyright laws, et cetera, using torrented sites. In one case, in Anthropic's case, the judge says, well, that's wrong. And in Meta's case, the judge says, it's fine. Like, what's your take on that? How's that happen?
My personal take on it is that the judge in the Meta case has it completely wrong. It seems unreasonable to me to say, and other scholars disagree with me on this, but my perspective, it seems unreasonable to say that pirating or torrenting copyrighted works is fine as long as you have some intent to use it for some transformative purpose in the future. That, how could that be? Anybody can train AI models now. So if I decide to go torrent all the episodes of Star Trek and make myself a Star Trek AI, I like Star Trek, make myself a Star Trek answer AI, that all of a sudden my torrenting all of the Star Trek episodes is going to be deemed lawful because I decided to make myself a Star Trek ask a question AI? That seems completely wrongful in my mind.
It's got a Robin Hood vibe to it, like you're like, well, I can steal it as long as I'm giving it away.
Right.
Yes. Very Robin Hood, right? Whereas the Bartz versus Anthropic case, I think, has it right in that if you lawfully obtain copies of the work by purchasing them, you can train an AI model to your heart's content as long as you're not creating additional copies that are going to be distributed to the public, and you're using the copies that you make only for the purposes of training the AI. It's not going anywhere. It's not getting duplicated. And in those situations, I think that's fine. You can use that to train an AI. Now there's other questions about whether just the mere fact of training an AI on the work is going to constitute some kind of copyright infringement. But I think the wrong copyright doesn't quite fit the wrong there because you're not reproducing or creating derivatives of precisely that work necessarily. I think there's arguments to be made, but that one, probably the courts are going to land pretty clearly on the side that if you're not making any copies, that's probably not going to be copyright infringement. Or if you're not making derivative works, that's not going to be copyright infringement. But when it comes to pirated works, the Bartz versus Anthropic case said it doesn't matter if you're using those works to train an AI system, and if the training itself is fair use, we're also going to separately consider the act of pirating content. And if you're downloading things that you didn't purchase that are copyrighted, then you're liable for that. Now, interestingly, the Bartz versus Anthropic case is going to go to trial on damages for that pirating of material. And because many times books are not only copyrighted but also registered, they're entitled to enhanced damages. Registered copyrights are entitled to enhanced damages, statutory damages for infringements. And that's based on a per work number. It can rise up to $150,000 per work if the use is willful. And so we could be seeing potentially millions or billions of dollars of copyright statutory damages in that Bartz versus Anthropic case, depending upon the size of the class of authors and the number of works that are deemed to be infringed.
Yeah, and that was one of my questions is like, that seems like it might be an existential threat for Anthropic. Am I understanding that correctly?
Yeah, I think they'll probably be able to find some way to get out of it, whether through perhaps some sort of insurance claims or perhaps some sort of deal with authors. We may see something like a settlement that could provide some sort of compensation fund for authors to receive some amount of damages that would be less than the $150,000 per work. I think that if this ends up going to trial and the court finds that there are millions and millions of pirated works that were all copyrighted, that's a huge amount of damages. But also a lot of these AI companies are generating millions and billions of dollars of revenue, so it's not necessarily going to be the end for them. It's just going to be very difficult, and they're going to have to make sure to use lawfully obtained works in the future if this ends up being the law. Of course, all of these cases are going to be subject to appeal, and it's likely that a court's going to stay any award, meaning they're going to pause the application of whatever their ruling is, like whether that's damages awards or something like that they're probably going to stay those pending appeal, and that these kinds of cases are going to go all the way up to the Supreme Court. That might take 10 years, maybe 5 years if we're lucky. And so, a lot can happen in 5 years with these AI companies. So I think also they may change their practices. They may start to find a way to obtain works lawfully.
They might have AI lawyers in 5 years doing the work for them. So it'd be like our large language model is the actual lawyer.
A lot of VC funds are obsessed with this idea of AI lawyers, but I don't think they understand that the ethical rules for lawyers would prohibit the use of AI lawyers. And so if you're working with a law firm, at least. So if you're working with a law firm, they can't have an AI lawyer sign off on anything, because anything that needs to be done by an attorney needs to be done by someone who's licensed, and AIs cannot get licensed as an attorney. So, for example, things like document review. Are you deciding whether something is privileged? That's something that has to be done by an attorney, even though AIs are better at making that determination. Now, a human can supervise and sort of be a human in the middle of the operation and review what the AI is doing, but a human ultimately needs to be responsible for all legal decision making under the licensing requirements. So this idea that we're going to have AI lawyers, it won't happen. I think we're going to have lawyers that use AI to help them. We're going to have lawyers who use AI inappropriately and end up with a bunch of hallucinated cases and get
We've
their
seen that already.
client
Yeah, we know
sanctioned.
that's possible.
But we're not going to have AI lawyers.
Yeah, that makes sense.
Yeah, it seems like, just my guess, it seems like, these AI tools for lawyers specifically, they're probably going to supercharge the people that are already established and making a lot of money, and probably not going to be great for a lot of the interns and people entering the space, because a lot of that kind of quote unquote grunt work might be automated, but it's also going to be incredible for the higher echelon power lawyers. What do you think about that?
I disagree. I think with law firms, oftentimes they're structured in a way that the highest person on the totem pole is somebody that has that client relationship, and that's what they're good at. And they completely outsource most of the prep work to lawyers that are underneath them, the worker bees. And so you've got this sort of pyramid structure where you've got the person at the top with the client relation skills, the person who's a smooth talker who can go out to drinks. And then underneath them, you got the service attorneys, the people that really know their stuff on that topic of law. And those people often know a lot of these things off the top of their head, and they don't need that much AI help. They know exactly what they want something to look like, and they have a lot of experience to draw on that's unique and not part of most training data sets that will result in them actually performing better than an AI on those topics. Now, I think this is true in very niche areas. So, for example, in trade secret law, where you may have quite a lot of an attorney's experience is based on their lifetime of interactions with the court system and with negotiating deals that are not available online and that are going to be very difficult to be part of an AI training system. This could be different for things that are really prevalent online, like basic property matters or things like that. And then with the worker bees, the interns, I think actually they're going to be helped quite a lot, because those are the people that tend to understand and be able to use new technology. And they are getting tasked with a lot of boring things that really could be done with AI. And by outsourcing, by making choices to outsource certain tasks to AI and then check them, this is important for my law students and recent graduates, check the work, but check it. And make sure you also send it up to a supervisor, let them know the context that you've used AI to assist you with this, so that everybody can make a decision that that's okay. And you all honestly should inform your client as well that you're doing this. But if you've done that, then you can really do less drudge work as an intern or an associate than you would otherwise be doing. I'll give you one example. Now, this wasn't AI, because when I was an associate, there wasn't AI, but we did have some early automation. I was once tasked with checking the news every hour overnight to see when the news hit about a specific thing that was happening with my client. And that was, I think I was a first or second year associate. And I thought, this is ridiculous. I should not have to go read the news once an hour on the hour overnight in order to figure out whether this thing has landed. I'm going to create a Google alert and figure out whether this thing has landed. And so I'm glad I created a Google alert and waited for the Google alert to tell me that something was happening that was related to this. And that was a great way to say, okay, that junior associate is the one that understands how to use technology in order to get rid of the drudge work. And the more senior attorney, they just wanted to know immediately when the thing hit the news. And they don't really care if you have an accurate way of doing so. Now, this is a task that I would not recommend using AI for. I really think a targeted search is better for this. You can have more accuracy. You don't want to end up in a situation where you get the AI going off on its own accord and deciding what's important and not important. But there are many other ways that AI can be used effectively to shorten the drudge work without sacrificing your responsibilities as a junior attorney.
What's your feeling about the, I don't know, about like sort of red tape slowing down the industry when it is sort of competitive between the United States and China versus the people who, deserve not to have their copyrighted works digested without compensation? Do you feel like we're finding the right balance? Would you like to see it moved left or right on that?
Personally, I would like to find a way to create a system of compensation for creators whose information is used for AI training, whether that's authors or even people that are posting online or on YouTube. That information is being used for training and it's beneficial and it's commercially valuable. I think there should be a way to compensate for that. Now, do I think that copyright is the right way to compensate for that? Maybe not, right? Because copyright statutory damages are incredibly high and they may outpace the actual harm to the person whose work was used for training or the actual benefit to the AI company. So I think that what would be better...
I also kind of mean like in terms of time. Like, is it better that they just move forward and break things right now and then they make billions of dollars and we sort this all out later so there's no slowing down of the industry?
Yeah.
Or the other?
That was the question that you originally talked to me about, I think, was about this idea of can you... Dylan gave me this very helpful tip to discuss on my YouTube channel, the concept of should you be allowed to get an injunction to stop an AI from engaging in training when they are using copyrighted content or potentially violating the law? Is this something that courts have the power to stop? Courts do have the power under their injunction powers to stop AI companies from continuing with training or from even using a model that contains copyrighted work if they find that that is a copyright infringement. But I think it's unlikely that courts are going to use their power for that purpose. I think that most courts are going to say that, well, number one, we've seen most courts saying that it's a fair use, and so we don't even have to get to the question of remedies because this is a fair use. It's not copyright infringement anyway. But the question of remedies is something that's under the judge's discretion when you've got something like an injunction. Now, there's two types of remedies under the law. You can have legal remedies, which are financial remedies, monetary damages, and then you can have equitable remedies. Equitable remedies are those traditionally associated with the old courts of equity, which used to be separate from the courts of law. And we look to that history to see what are the powers of judges to grant equitable relief. Equitable relief includes things like saying you may not do this anymore, or I'm going to stop you from doing this by taking that item away that's infringing. And so that power of a court to say, I hereby stop you from doing this, that's an equitable power. And those are limited by the historical context in which those were previously used. So courts are generally reluctant for equitable decisions to simply say, hey, there's been a legal violation, and therefore I'm going to issue a broad injunction stopping it. Traditionally, in courts of equity, they would weigh the effect on the public. They would decide what's fair. They would decide what's reasonable. And so many courts will say, even if there's some kind of harm here, I'm not going to issue a really broad injunction that says, destroy every AI model or something like that. We're going to try to be reasonable about this. But courts haven't even had to reach that because so far they've been saying it's fair use. It's not a copyright violation.
Mm-hmm. One interesting thing I think you mentioned in your video is that the judge was talking about this idea that if we put too many roadblocks to these things being developed in the US, they might go to a different country, which I was surprised to hear that that's something that's taken into account in the court system, because that almost seems maybe a little bit more political. What do you think about that? Do judges take that into account? Should they?
Yeah, the court decisions that we've seen so far have explicitly said that it is not appropriate to take into account the impact on the United States' competitive position when deciding whether to grant or deny judgment in a particular case. And that makes sense. Courts are supposed to be a branch of our government that's deciding cases and controversies between two groups or multiple groups of people, but specific people or specific companies, not to make a decision that's going to favor the United States' position overall or that will favor the judge's own views of policy. Judges are supposed to make their decisions based on whether person A violated the law and owes some compensation or must stop doing something that harms person B. So it is, in my mind, inappropriate for judges to consider things like the geopolitical climate or whatever it is in making their determination of whether or not there has, in fact, been a copyright violation or whether there is fair use or not. However, traditionally in courts of equity, courts may consider the public interest when crafting the scope of an injunction, when crafting the scope of an order saying what the person who's acting wrongfully has to do or stop doing. So this would be something like, instead of saying that you have to destroy your model, they may say, let's look at options to take a year to put guardrails on your model to prevent this kind of thing from appearing in the outputs or something like that. They might find other ways to limit the scope of an injunction in the eyes of the public interest. And that's permissible because that was historically done in courts of equity. But when it comes to liability, did somebody commit the act? That's an area where judges are not supposed to consider the impact on politics or the geopolitical climate.
Sometimes it feels to me too like there's almost a different law system when it comes to like military or national protection. So sometimes I wonder if now you start getting into the territory where it's like national defense arguments and then more, I don't know, it seems like more power is like gifted upon those kind of systems from a layman's point of view.
Yeah, I think the one place where I see this coming into play the most is in patent law. So there's this court called the now the name is blanking on me. I used to do a lot of work there. There's this court called the International Trade Commission, and they handle customs cases that decide whether or not a particular good is allowed to be imported into the United States. And as part of that court's jurisdiction, they are allowed to consider the public interest, including things like national security. And there are situations where they've said that a particular device is so important to national security that we can't block it, even though it may be infringing a patent. That's the only case where I've seen judges say something's important for national defense, and therefore we're not issuing the remedy that we're entitled to issue.
Interesting. Oh, that makes sense. And I know Sam Altman actually had one of his deals blocked out of I think it was out of the Middle East, and I also had some maybe Chinese investors that some subsection of the government like actually came in and blocked it, reversed it, had them refund the money, which I was like, that's interesting. Okay. One thing I kind of wanted to mention is a year or two ago when I was starting my channel, I used to kind of look at the various lawmakers, whether that's like Senate, judicial, executive, and it was kind of frustrating because not a lot of them have STEM experience. Not a lot of them have kind of a tech background. I was like, oh boy, like I wish we had more people with some sort of STEM background making these decisions, not because a lot of them are either have a law background or a history background, but it's like I wish more of them had some more understanding of this stuff. And in this case, we had in the Bart's versus Anthropic, we had Judge Alsup, who apparently seems like he really gets it on a much deeper level.
He's a math major, and
Yeah.
he spends a lot of time digging into the technology of the cases before him. He's famous for learning coding for a previous case that involved coding.
Oh,
that's cool.
He learned
like
how to
to hear
code
that.
for the purpose of ruling on his case. Yeah.
Music to my ears. That's absolutely excellent. Yeah. So what do you think about that? How important is it for the lawmakers and judges and all of those people to really, because I mean, this is going to be a much bigger part of our discussion in the law and everywhere else. It's going to intersect with all types of different things. How important is it for them to truly grasp how this stuff works?
You may or may not know, but I recently wrote a paper that looked into the educational backgrounds of U.S. federal judges and looked into the percentage of U.S. federal judges that have STEM educations. The percentage is very low.
Okay.
There's a 7% of U.S. federal judges have some type of STEM major, pretty broadly defined. I included architecture as a STEM major in there, and nursing and things like that. So anybody that has that sort of experience with scientific method, I bunched them into that category, and only 7% of judges have that background. Now, when you have so few judges that have any kind of STEM knowledge, it makes it incredibly difficult for those judges, in my opinion, to fully comprehend the scientific and technical issues that are becoming more and more important in the modern technological era. In particular, on the Supreme Court, we have 0 judges with any STEM education. This is something that Justice Stephen Breyer was very passionate about. He thought that we needed more judges with STEM education. He's not on the court anymore, but we needed more judges with STEM education. This is controversial. There are some other justices that said, no, we don't want more judges with STEM education because then they're going to be bringing their own biases into these cases and making scientific decisions that are more appropriately left to agencies. So Justice Scalia had that opinion. But lately, we've also had some changes in Supreme Court precedent that mean courts have more and more obligations to decide scientific topics. So we've had changes in the deference owed to agencies, and that results in courts needing to make a lot of initial determinations without the aid of agencies as to the meaning of very complicated scientific statutes, things like the statutes that govern environmental protection or drug approvals or other difficult and complex topics. And in my opinion, between things like environmental regulations, I'm sorry, my cat just got in here.
Even better. Oh my gosh.
Wow. What kind is that? What's the breed?
This is a tortoiseshell cat. She's a American Shorthair.
Very
And
cool.
her name is Kitty.
All right.
Sorry, where was I?
I love cats. No, this is great.
Who
We had
cares?
one
Let's pet the
interview.
cat.
Yeah, we have one interviewee that while he was talking, his cat, I just saw a blur across the screen,
Yeah.
and then it stepped on the button that muted his mic.
Yeah.
So like, oh, this is great.
Oh no. I totally forgot what we were discussing. I was distracted by cute cat.
STEM, and we're talking
STEM majors.
STEM majors
Yeah,
and
so-
how. Yep.
In my opinion, we don't have enough STEM majors in the judicial system or frankly among legislators or presidents either. I think that we need to have people that have more of an understanding of technology to make good rulings on those issues, whether it comes to complex scientific regulations or the context of interpreting patent claims, which can be incredibly complicated, or even things like toxic torts, like whether a chemical causes injury to a person. Those are all things where a basic understanding of science can be incredibly helpful for deciding the ultimate issues in the case.
Yeah, another big issue I feel like from what I've been hearing, I know a few people that worked in the government, and so one of the things that I'm hearing is that, for example, with this whole interest in AI, a lot of the people, lawmakers, don't know too much about it, so they need to kind of get some basic education about it. So where do they get it? Well, all the big tech firms send the lobbyists that have kind of a tech background to explain things to them. But it's also like, okay, but there's a reason why they're there. They might skew them one way or another, right? If I don't want to, whatever. Like if let's say they're worried about China releasing open source models, they might say, oh, but China could use this to like, destroy the U.S. or what, or like, well, we need regulations because otherwise there's this X risk from AI that might work in their benefit, right? There's a bit of an issue there too. It's like what are they teaching these people? So that's another kind of issue that I'm worried about.
The TikTok one is another example where I feel like legislators just did not understand the technology at all. I don't know if you guys watched those hearings, but when deciding the legislation that was going to effectively ban TikTok, you had legislators up there asking things like, does TikTok access my Wi-Fi? You're like, well, if you use Wi-Fi to get on TikTok, it'll go over your Wi-Fi. And then, and there was somebody that said, well, they use eye tracking? They use eye tracking, and they can watch what I'm feeling and then serve me more content that's going with what I'm feeling. And they said, we only use eye tracking if the user gives permission for a filter or something like that. We're not using eye tracking to watch your emotional responses. And so it just reflected a profound misunderstanding of the current state of technology and even the current use cases of that technology. I think we've seen less problems with Congress misunderstanding technology than we have with the courts. Part of that is because Congress does have help, not only from members of industry that are educating them on these topics, but also many Congress people have in-house staff that are technically trained as well. And we see, for example, in the patent context, I have a friend of mine who was working at the United States Patent Office as a technically trained lawyer, and became a judge over there, and then ended up getting sort of stationed at Congress to assist with making difficult or helping with difficult decisions about technology and patent law issues. So Congress does have a lot more help than we see in the judiciary, where oftentimes it's just the judge and whatever clerk who is somebody fresh out of law school, typically without a scientific education. They're the people that are trying to decide these complex issues, and they often get it wrong. We've seen this. The Supreme Court, for example, recently had a patent case where they, in my opinion, although not all others agree, where, in my opinion, the opinion suggested a misunderstanding of how DNA worked. And that ended up changing how that decision came out. They ended up finding that certain medical diagnostics were not eligible for patent protection because they said this is all just natural. It's just DNA. And they didn't seem to understand that there are differences in how many of those medical diagnostics tools are using DNA. So we've seen some problems when the Supreme Court doesn't have any understanding of technology. And the Supreme Court is way further off than most district court judges. You see district court judges who are taking the time to educate themselves on the scientific topics. They're having technology tutorials, or they're trying to get education online. Some of them are even asking AI to help them better understand the topics, which is, bordering on problematic if they're delegating their decision making, but at least they're making an effort. Whereas the Supreme Court, in my opinion, not only has no knowledge of science and technology, but also seems to have no capacity for trying to learn that material. They don't attend trainings. They don't try to understand new technology.
Do you get the sense that anybody on the Supreme Court could explain the scientific method?
I think maybe one or two of them could remember what they learned in high school about scientific method, but I don't think that they could really comprehend how it's applied in any particular technology case without assistance. I think people might disagree with me on that. A lot of people say, oh, they're the Supreme Court. They could do anything. They'll learn it. It's fine. But you don't know what you don't know if you've never had an education in science and technology. You don't know that there needs to be some sort of statistical significance to draw an inference from statistical data that you have before you, for example. And if you don't know what you don't know, then they're not going to know that some statistical data before them is problematic. They're not even going to know that they need to check it according to scientific principles. That's what becomes problematic. And that's the difference between a STEM educated judge and a non-STEM educated judge. They know what they need to go look up.
So, and kind of speaking
Sorry
about
for my stomach rumbling.
Oh, no. And speaking about science and kind of the scientific method, we're seeing a lot more things right now that seem to suggest that science progress will be accelerated through the use of these AI models. We've seen something like Google DeepMind's AlphaVolve, which has done some pretty incredible stuff in a broad range of industries, or from math to improving hardware to improving AI, its own training abilities. And what I think a lot of people didn't realize about that is that was from like a year plus ago when they released that from the 2.0 model. So what they're working on right now might be even much further ahead. And I believe it was Max Tegmark that in his book Life 3.0, he kind of envisioned the scenario where in the future, you're going to see all these little companies all across the world pop up with little improvements, like they improve the airplane wing, they improve our DNA sequencing technology, they improve satellites and this and this and this and this. And then we realized that it's all one major tech company that actually cracked the code to AGI and now is just like patenting all sorts of stuff all across the board. And when I saw Google DeepMind's AlphaVolve, I'm like, oh boy, does that look kind of like the precursor to that? So can we talk about a little bit AI and patents, AI and I don't know, trade secret? Like, how does that whole thing? How does the law and AI, potentially AGI, where do you see that going?
Yeah, that's a great question. So with AI and patents, this is still a quickly unfolding issue, and it's starting with the Patent Office. Right now, the questions that have been decided are limited to the topic of that you cannot have an AI co-inventor, that all inventors have to be human, and if you make an invention with an AI such that the AI is doing the kinds of steps that a human would ordinarily be doing, like they're doing the conception of the idea, they're doing what's called reduction to practice, meaning you're showing how to make and use the concept that you've come up with. Those are necessary for obtaining a patent. If an AI is doing those steps, the AI cannot be listed as a co-inventor, and also you may not be entitled to patent protection at all if you don't have a human inventor that engaged in those steps. And so if they're under current Patent Office policies, they will not grant patents if an AI is responsible for the conception and reduction to practice of an invention. But you may be able to, in some instances, use AI tools to assist you, as long as the human is the one conceiving of the concept and showing how to make and use it.
So, okay, so like Isomorphic Labs is a company that broke out of Google's DeepMind division from the AlphaFold kind of invention, and it's folding proteins to make drugs. So is that, you just say the same thing that you said to me, like in technical terms, like does that mean that they can have a patent on a protein?
Yeah, so if you try to apply for a patent on a protein that you discovered because you put it into an AI system and you put the problem into the AI system, I'd like a protein that targets, suppresses GSK3. This is something that relates to Alzheimer's. This is something that I've been looking into for a book that I'm working on. Let's say you have something that is targeted for the suppression of GSK3, and then the AI spits out, hey, this protein is going to work. Here's the code for that protein. Here's the DNA code for manufacturing that protein. And if you use this, it's going to suppress GSK3 and therefore would theoretically be helpful for the treatment of Alzheimer's disease. If that's the case, you probably won't be able to get a patent on that, because even though you had the concept of saying, I'd like to target this particular potential target, the AI is the one that came up with the thing that solves that problem. And it showed you how to make and use it by giving you the DNA sequence for that protein.
So isomorphic labs, to be profitable, would then need to say, okay, we can't own the actual the sequence. So we'd have to be the first to market to, I don't know, sell some part of the system, the pipeline.
So the FDA does give some limited market exclusivity for new drug compounds, regardless of whether you have a patent on it or not. You can get market exclusivity from FDA approval. You can say you're the only one that's FDA approved to sell this compound. But you might not be able to get patent protection on something like that. And patent protection is a lot more valuable because it's longer. The longer you can get market exclusivity and keep competitors out, the higher the super competitive prices that you can charge. And with a patent, you can get 20 years or sometimes even more if you have additional patents that you file on methods of use or different formulations. You may be looking at 20 or 30 years of market exclusivity as a result of strategic patenting. Whereas if you're just creating something new that's not eligible for patenting, you may be looking at something like 3 to 5 years of FDA exclusivity.
You know, this seems okay to me, though, because like when I think about what a patent was invented for, it was to motivate somebody to put a lot of effort into inventing something, usually some mechanical thing from a different era, but you know, a significant cost and work and thought, and then they build something and it can't just be copied. They get to reap some of that reward. So that motivates them to build something in the first place. But when we're talking about a model that's built and can pump out millions of these things by the second, it doesn't seem as important that you get a 20-year patent.
Yeah.
So maybe this is not so bad.
Yeah, I think that makes sense. I think a lot of pharmaceutical companies would disagree with you and say that it's not only the research and development of a new drug, but also the price of commercialization that drives up the need for having higher revenues. And pharmaceutical companies might say the patent incentive is necessary for the commercialization and manufacturing of a drug for a certain amount of period, you know, sending out sales reps and things like that. This is actually a chapter of, there's a book that I'm working on called Intangible, How Intellectual Property Affects Our Lives. And one of the chapters is on Alzheimer's disease treatments and how there are some treatments that are available that have been sort of so long-standing that they are not going to be likely eligible for patent protection. And as a result, nobody's marketing them. They're available for 43 cents a pill over the counter, and so nobody's marketing them. Your doctor won't find out about them. The cost for pharmaceutical companies to commercialize their inventions is incredible. Even if you can get research cheaply, which is admittedly one of the biggest costs, you still have enormous costs of things like sales representatives doing doctor education on how to use the compound and on the compound's benefits. You have enormous costs when it comes to FDA approval. All of those things are things that are very difficult to justify if you don't have the patent incentive. So in pharmaceuticals, it's one of those classic cases where there probably is quite a lot of benefit to having patent protection. And that market might look very different when it comes to AI-created inventions that are not subject to that protection. That might be an area where, similar to those long-standing drugs, like the example I use in my book is benfotiamine, which is a vitamin derivative that's available over the counter, has something like 5 times the benefits of pharmaceutical drugs in the treatment of Alzheimer's disease. If you're looking at things like that and you're comparing it to situations like AI-created inventions, those are both examples where we might need some new protection. We might need some additional, more extensive marketing exclusivity from the FDA. So we may need more extensive marketing exclusivity from the FDA to justify the commercialization of things like AI created inventions that are not eligible for patent protection, or longstanding safe compounds or natural remedies that are likewise not entitled to patent protection in most instances.
Interesting.
I feel like X Prize kind of figured this out. I think there should just be the government creating giant prize pools for the first to accomplish something, and then they just get the money instead of like using the patent to protect their future revenues, because then it stifles innovation after that. But
yeah,
my
that's
two
really
cents.
insightful. No, that's really insightful. It's one of the things, I have a class that I teach called Innovation Law. We go over policy implications for innovation, and we have a topic day on grants and prizes and how that compares to the patent system for generating incentives. So you're right on the nose as to potential alternatives for incentivizing innovation where patents may not be available.
And just so I understand, this idea that you have to have a human inventor and you can't have an AI co-inventor. My first thought is that, okay, is that bulletproof? Is there some simple way to sidestep that? Like, oh yeah, I came up with it, but I wrote down here that I had an idea. Or is that pretty bulletproof in that if they fully use AI to do it, it's hard then to get that patent?
If you fully use AI to come up with the idea and show how to make and use it. So the example of AlphaFold or another company generating a protein that could be a good target and demonstrating that it will work and showing what DNA sequence is necessary to produce it. That's one where it's pretty clear that you're not going to be entitled to patent protection under the current patent office policies. There's also been case law where you can't name an AI inventor in that situation. What starts to get a little more on the cusp is when you have some combination of that. And we'll have to see how that plays out with more applications and more court cases, that maybe somebody sues because they get their application denied and the court gets involved to review that. Those are things where we're going to need to see more cases. So things on the cusp might be that you, the human, determine that GSK is an interesting target for Alzheimer's disease, and you believe that a protein that's folded with a certain shape is going to be useful at targeting that. So when I was an undergrad, I did work on protein folding, and one of the things that I had to do was sit around in the lab and adjust the DNA sequence to change how it folded so we could model it and see if it would bind to where we wanted it to bind. And if you're doing that same thing that you would have been doing on a computer 20 years ago in order to discover a potential target, or in order to discover a potential protein that you could use, and all you're doing is having AI help you to speed up the process, but you know how that protein needs to be folded. You just need to understand what the sequence is that gets you to that folding shape. Then that's an area where it's much more on the cusp. And I think that the patent office is going to have a much harder time denying an application like that when you're using the argument that you're just using AI to speed up a thing that you previously would have done by hand in order to generate the same conception and reduction to practice that you're getting to now. We don't have case law yet, though, but we'll see that soon, I think.
Yeah, Alpha Evolve is going to be fascinating because it's exactly what you're talking about. I feel like it's on the cusp in a sense that they give this AI model and there's some scaffolding around it, and you can replace the AI model because that's kind of driving it. But they give it like, here's all the database that we have so far on whatever subject, whether that's math or optimizing hardware or optimizing the training of the AI. And then the human scientist comes up with a way to grade the output, some sort of like a value function. Like, this is better, this is worse. So if you're like packing, if you're like trying to improve the efficiency of a car, if it can go longer on less gas or whatever, then it's like good. And if it doesn't, then it's bad, or something as simple as that. And then it goes through this evolutionary tree search and often finds solutions. Like one of the math things, it's stuff that we haven't been able to improve on in like 60 years. to this math algorithm. So it's like very interesting. So is that the human that came up with that because they wrote the value function, and they also kind of control how far down certain branches it goes, or so I feel like that's going to get really complicated.
It'll be complicated, and sometimes judges or patent office, they might not get it right, because these are things that don't necessarily have a right answer. These are fundamentally policy choices, where exactly you draw that line. And it's very difficult for administrative agencies and for courts to be doing that kind of line drawing that is fundamentally a policy choice at the end of the day. They try to fit it into, we're just interpreting the law here. But fundamentally, policy choices start creeping in. And when that happens, that raises a red flag for me that says this is a time that Congress needs to step in and provide some clarity, right? If you have administrative agencies and judges unsure where the line is on the law and really struggling to make that line without making a policy choice, that should tell you Congress needs to step in and make the policy choice for them.
Right. And I'm curious what your feeling is about what would happen, or what you think should happen if, let's say, Google, I'm just using them as an example because they have Alpha Evolve. There's other companies that are doing very similar work. But let's say they patent such a large number of things, normally equivalent to 20 years of regular progress across mathematics and hardware, just across everything. And they put in hundreds of thousands of patents across all these different industries in a few months that normally would have taken us decades of research across the entire world, across different companies. Like, at some point, do we pull the plug on the patent system or have to rework it somehow? Or do we just allow them? How do you even begin thinking about that?
Yeah, I don't think that's going to be much of a problem, in part because patents are very expensive. I think the thing that actually creates a larger risk of that happening is legal services for drafting patents getting less expensive. That's going to result in more and more patents. Right now, you have huge application fees, huge maintenance fees. You could be looking for a typical patent for a large company. There are some exceptions for small companies, but for a large company, you're spending tens of thousands of dollars just on government fees for that patent. And then in addition to that, you're going to have at least 20, if you're getting a super cheap patent lawyer, $20,000 for legal fees for drafting the application. And if you've got a really great patent lawyer, you may be, for a complicated patent, looking at something like $150,000 or something like that. So this is an area where for most companies, it is not going to make sense for them to file a ton of patent applications or to get a ton of patents and maintain them. We actually see large companies weaning down their patent portfolios. They have granted patents, and they're trying to figure out how to reduce costs of all the maintenance fees, the tens of thousands of dollars of maintenance fees. When you add that up over thousands of patents, companies like Intel or IBM, these are companies that are paying hundreds of thousands of dollars in maintenance fees every year for all the patents that they have. And so they may make decisions to not continue to pursue or not maintain patents that they don't deem to be as valuable. So I think it's highly unlikely that we're going to see companies applying for and maintaining thousands of patents, because it's just the metaphor I use is, my dad used to say, a boat is a hole in the water that you throw money into. I feel like if you use AI patenting to generate thousands of patents, then the patent office is just, a hole in your asset portfolio that you're throwing money into, right?
Yeah, not to mention even more money to enforce it every time you feel like somebody did infringe on one of those things. So,
yeah,
absolutely.
Patents are expensive. We won't have a problem of people making too many of them.
What about completely international, I guess, like patents and data? Like if there's a bunch of books in India that get digested by one of these systems, does our country even care? Or is it usually like a system that we're defending, like other Americans and the American GDP? Or I don't know. Just talk to me about the international implications for some of the same stuff we've talked about before.
For something like AI training, we have... this is mostly going to be a copyright question. For something like AI training, we have protections that apply internationally for copyrights that are applied for in other countries. We have something called the Berne Convention. And because of that, we will generally allow copyrights to apply based on their original applications in foreign countries. And so we probably won't see much of a difference in how foreign copyrights are treated versus originally domestic copyrights. I think we're still going to see that authors gain protection that is going to be subject to the same rules as domestic authors are entitled to under existing law. When it comes to the patent space, this gets interesting on the international level because other countries have different patent laws than we do. And this is there's generally a lot of overlap on the important issues in developed countries that have signed on to international treaties like the TRIPS agreement. But there are some smaller countries where they may not even be obligated to protect the patents that you have. And if you didn't apply for a patent there, they're not obligated to protect it. So you could imagine that one use of artificial intelligence would be to say, if you're in a small country that doesn't have a patent office that major companies usually apply for patents in, let's say you're talking about, let me think, let's say you're in the Congo or something like that, or I can't think of another good, some small country. Think about a small country that, in terms of GDP, that where people are not going to think that that's a great place to seek extensive intellectual property protection. And if you have some small country in that situation, they may decide to use AI to say which valuable patents in other countries do not exist in our country, and therefore I can use that patented technology now before the patent expires. So if, the US consumer won't get competition on this brand new pharmaceutical drug for 20 years, maybe we can produce it locally without violating any patent because the owner didn't apply for patent protection in our country. So AI could be useful for identifying those gaps in the law, gaps in legal protections that can be used to exploit those gaps to help the population of those smaller countries.
Oh, wow. That's almost like a cybersecurity issue, but in terms of where the money and patents would be. Because you're right. Yeah. If something was happening in the Congo, maybe some kind of medication, maybe people would either try to get that, package delivered into the US from the Congo, or they might even just fly there to receive a treatment. And then, big pharma in the US is missing out on that money and has to deal with it.
But oftentimes these pharmaceutical companies don't really care about missing out on the market in those small countries. For one thing, oftentimes the benefits that they would get from selling in that country are often so small that it doesn't justify the cost of the lawyers to get the protection in that country. And so they'll just kind of tag it as a loss.
Yeah, and that's going to be interesting to see because, it sounds like there's a lot of applications where, for one, for the country to benefit the citizens, the residents of that country with drugs that might have been very expensive elsewhere. But also, I'm sure there's a lot of business ideas that people will do to maybe create something digital to where you're able to replicate something without certain guardrails, like an AI model or something like that, where other people could, for example, VPN from the US to use that. And I feel like billion-dollar companies might be created in these little tiny countries that just kind of avoid that, right? Is that realistic?
You can't target the U.S. consumer if you do that. There's something called these long-arm statutes, this idea that you can extend the reach of the law to something outside your territorial jurisdiction if that company is targeting the citizens of your state or of your country. So if you have a company that's based in Singapore, for example, and it is asking U.S. consumers to VPN in so that it can use some sort of patented technology on their servers, then that's going to be problematic because you're reaching out to those citizens.
Yeah, as I'm thinking,
and so you can still face liability.
as I'm thinking about it, I think to Kim.com, if everybody knows who that is, right? So he was in New Zealand, I think, out of U.S. Extradition and, doing a lot of the piracy stuff. And then he had this massive mansion. And I think either it was like the FBI or the New Zealand SWAT team, the equivalent, that they just descended on his house, broke through the doors, like dragged him out. And he's like, legally, they could not have done anything, but they still did. So it's like one of those things where it's like, okay, maybe you think legally you're protected, but you don't want to mess with the U.S. interests, I guess. That makes sense.
That gets really complicated because there are international laws that protect countries from having the United States sort of invade their country in order to effectuate the U.S. laws there. So generally, when that kind of thing happens, it's as a result of cooperation between the different governments. Otherwise, that government would probably complain about that happening.
Yeah. Do you know anything about what happened there with Kim.com?
I don't know enough to intelligently talk about it. I remember the case, though. I remember it, but I wouldn't want to state what happened because I probably misremember something.
Yeah, I wasn't sure either, but man, I like looking at that. It's like, okay, don't mess with the U.S. government, I guess.
What are some of your thoughts on the kind of ways that AGI has been defined so far in the Microsoft and OpenAI legal battles?
And Elon Musk's lawsuits too. Yeah, that's kind of part of that.
Yeah, so this is a really interesting area that I've been talking about for a while. So with the Microsoft versus OpenAI, or I shouldn't say versus because they haven't sued each other yet, with the Microsoft and OpenAI potential dispute.
Negotiations.
Yeah.
We have, at the beginning, OpenAI stated that it was in its structure of its company. It was designed to favor the use and development of artificial intelligence for the whole of humanity. And as part of this, they committed in their initial structure to not commercialize or exclusively license the AGI technology, artificial general intelligence, once it got to that point, that would be something that they are not going to allow to be part of an exclusive commercial deal that would essentially restrict the public from being able to benefit from AGI. We don't have the exact terms of the contract between Microsoft and OpenAI, but we understand from news coverage and commentary from the Microsoft and OpenAI representatives that the deal between Microsoft and OpenAI currently includes a licensing arrangement for intellectual property that would expire to the extent that that intellectual property includes an artificial general intelligence, or AGI. And so we've seen also some people commenting that Elon Musk, for example, has been trying to say that OpenAI has achieved AGI and that therefore this provision that restricts OpenAI from licensing AGI to Microsoft or others should kick in and cause the license to Microsoft to expire as to that new AGI technology. Now, it's very difficult to establish what constitutes AGI. And so that's why the OpenAI structure has in place that the board of OpenAI is going to be the one that decides whether something is AGI. In the Elon Musk lawsuit against OpenAI, Elon Musk asserted that OpenAI had achieved AGI on the basis of some statements of OpenAI engineers that OpenAI had achieved AGI. But under the current structure, it's the board of OpenAI, not any individual engineer, that would decide whether they've reached AGI. And we've seen in some news articles that have been published in the last week or so, including in Fortune, I believe, that have stated that Microsoft is trying to get that restriction of licensing AGI off of its current arrangement with OpenAI, and that OpenAI opposes that and does not want to get rid of that restriction. But of course, this is all based on some, interview with unnamed sources kind of thing. So we don't really know exactly what's going to happen until we see what the final deal is between these parties and how they proceed in the future. We'll be able to tell when OpenAI decides to restructure, if it does so, to change its rules around AGI.
Do you think you'd have an easier time arguing that AGI has been achieved or hasn't if you were to have to deal with that question?
I think as a legal matter, because the OpenAI structure defines AGI as when the board says there's been AGI, it would be a lot easier to say there hasn't been AGI because the board hasn't said that there's been AGI. So as long as the legal definition for purposes of OpenAI is it's when the board says it happens, then it's really hard to argue as a
It's
legal
really just
matter
a choice. It's like a choice they can make when they want to, more so than an argument.
Exactly. So, theoretically, they have to do that in good faith, right? If they have AGI and the board is saying, no, we don't have AGI because they just don't want to say that as a legal matter, then, or vice versa, maybe they don't have AGI and they're saying that there is so they can get out of that contract. That's an area where you might have some other type of corporate law claims against them for, but that would be really interesting to explore. I think right now there's not a very good, clear bit of evidence that they've definitely reached AGI. AGI is hard to define. And I saw a recent interview with Altman where the host, it was on the OpenAI podcast, the host asked, well, so have you achieved AGI? Will you achieve AGI with GPT-5? And Altman says, I don't really want to talk about AGI, but what I'll talk about is superintelligence. And I think we'll get to superintelligence. Now, Altman is so smart because he knew, I think, that if he were to say, yes, we've achieved AGI or we're about to achieve AGI, that would have all kinds of legal consequences, right? And so he said, let's not talk about AGI, let's talk about superintelligence, right? So he's being careful to avoid legal implications by making a declaration of what constitutes AGI. It's a lot easier to argue that OpenAI has achieved AGI if Altman says that they've achieved AGI than it is if some random engineer says that they've achieved AGI.
Right. Yeah, it's so interesting because a lot of the stuff is we don't have definitions for, and even like simple words that we knew before, like forget AGI and superintelligence. It's like think or reason or like there's so much more here that we need to like kind of redefine as we enter this new AI era. Speaking of Sam Altman, and earlier you mentioned that it would be good to have some sort of a fund for creators, artists, writers to be compensated for the stuff that they've produced that goes into training these models. We don't have anything really like that on the books or anything. At some point, Sam Altman was actually presented that question, and his take was like he's like, you know what, that's an interesting question, but I think very soon it won't even matter because we're going to get to the point where a lot of the synthetic data that the data produced by these models will be used to train the next generation of models. Let's assume for a second that's true. It may not be true, but let's say just for the sake of the argument, it is true. And let's say like, so all the music and all the writings and all the images that go into training these models have been produced by AI. So zero human data. There's still, and Sam Altman suggested that we need a way to still compensate artists for the stuff that they're doing. Is there a way that we can approach that through maybe a new law that's passed? Like, how do we even start thinking about that?
Yeah, I think the most likely way for that to happen is through settlements from lawsuits, that a company could agree as part of a settlement that they're going to establish a fund to compensate artists that were part of the training model. I think when it comes to the question of synthetic data and whether that would solve the problem for AI companies, I think it's probably true that you can lawfully train AI models on synthetic data without violating any copyright law, as long as the synthetic data is not substantially similar to any copyrighted input. So if you're using not only synthetic data, but synthetic data that has extreme effective guardrails to prevent any copyrighted data from appearing in the new synthetic training data set or substantially similar works from appearing there, in that situation, you're not going to violate any copyright law. Why is that? Because AI-generated content is generally not entitled to copyright protection. And also, even if it were entitled to copyright protection, the owner of that would be the person that created it. And theoretically, the companies that would be training using synthetic data would be the ones generating the synthetic data. They wouldn't be crawling the web looking for synthetic data, right? But theoretically, they could, right? If you've got AI tagged on your video and you've used an AI avatar to make your video, you probably are not entitled to copyright protection in the AI-generated portions of that video, specifically the avatar's movements or the avatar's image, right? So probably a AI crawler could just say, hey, I'm going to take everything that's tagged as AI content, and I'm going to use that as my training data set, and therefore I'm not using any unlawful copyrighted data in my training data set.
That's crazy, Wes. That means like that podcast we did is kind of like synthetic data for a new model. We didn't even think, I mean, I didn't think about it. It's such a weird thought. Yeah.
And I wonder if YouTube or Google knew how incredible YouTube was going to be for training the various video models. Because I mean, I'm sure somewhere we all, when we're uploading our stuff to YouTube, I'm sure somewhere we signed all our rights away. So now, and it's pretty obvious that VO3 is being trained on, I mean, I don't know, but I assume it's being trained on YouTube videos. I
for sure
would bet on that.
Well, who would have thought XAI now owns what was Twitter and then X? Because like now that's the tiny part of the AI company when that was supposed to be the social network that was, I don't know. It's wild how much data
Elon
is.
Musk knew that when he was looking at buying X and Twitter at the time. The whole goal was to use it for AI training, I believe. He is sort of an AI maximalist.
So you see Sam Altman wrote that one tweet that was like, oh, I'll buy it from you for $11 billion if you want. And
right.
he was like,
was
I think
funny.
he wrote back like slimy or something. I forgot.
Right.
Shyster or something.
Yeah.
And so you said something very interesting, that AI generated content is not protected. So can we dive a little bit into that? Because I think this is very, first of all, actionable for a lot of people on YouTube, on social media, a lot of artists. And I think I find myself that I'm kind of confused as well. Because I mean, for example, if I take an image from Midjourney, for example, am I allowed to use that? Is that belonging to somebody else? I know that Suno AI, which produces music, I did a live stream where I played, when they came out with a new version, I played some of it on my live stream from various artists that were trending on the page. And then later I got a copyright where they take your, on YouTube, they take your...
You got a takedown for...
It's not a takedown. It was like the thing where they take the money.
Copyright strike?
Money.
I don't think it's called a strike, right? It's a copyright...
No.
You know what I'm talking about?
There's three tiers. There's three tiers to it.
Yeah, the copyright claim.
Yeah.
Right.
Yeah, just copyright claim, meaning that they'll take the AdSense money, but not
exactly.
You're not exactly in trouble.
Yeah, you're not in trouble.
But that's wild because that's based on an assumption that you're using copyrighted music. So it seems like the engine that was trying to flag that found substantial similarities between the Suno work and some other artists' work. Did it say what artist's work it flagged it as?
You know what?
Or the original creator that made it on Suno uploaded it to YouTube, and then they were the first, and it assumed that person was the creator.
That's a great question.
You didn't make the music on Suno. You made a different person uploaded the Suno created music that they made, and then you used that Suno created music.
So on the Suno website, you can make your music public, and then people vote it up, and there's the trending ones, like the best of the day. So when the new model came out, Suno 4.0 or whatever, I live streamed it, and I played the stuff that was trending. But a great question whether that was Suno or the artist, or it was similar to some other music. I'm going to double check that in a second.
I think Dylan's right. Probably you have to check, it'll probably tell you whose music it flagged it as, but probably the person that originally created it, uploaded it, and therefore it ended up in the copyright management system as their work.
Because
now,
go ahead.
It may not be protectable by copyright, but the system is flagging it as that.
Yeah.
Because it was uploaded.
And YouTube has their own, they call it the copyright system. It's not quite, it's a little bit different. But what's interesting is the music that I produced while I had the paid Suno plan, they said you're able to use it for commercial purposes. None of that music ever gets flagged as long as it's only that music that I use. But if I use something on the trending page, it looks like there might be issues. So can we talk a little bit about... I guess that answers my question. So you're saying that in general, AI, so if I go to Midjourney or I use whatever clips I want in VO3, from VO3 that other artists or other producers, whatever you want to call them, have generated, legally, I have no liability. Is that correct in the US?
In the US, under current Copyright Office policy, the creator or the person who prompts an AI engine to output an AI-generated work, they are not entitled to copyright claims. They don't own that music. They don't own that artwork. And it's public domain because it's not eligible for copyright protection. If you use generative AI to develop anything, you are not entitled to copyright protection in the output of that generative AI. And that means that anything that is produced that way would be public domain because there's no legal basis for restricting your access and use of that AI-produced content. Now, that could change,
but if
right?
If it closely resembles someone else's work, can't you get in trouble? Like there's a stormtrooper vlogs, where somebody's using VO3 to kind of vlog the day in the life of a stormtrooper. It's clearly a Disney IP, but I understand it was AI generated.
Is that a parody thing that they get away with?
Yeah.
It generally would be considered satire, which is not a fair use. So that actually would be problematic, but it's not problematic. It's problematic for a different reason. It's problematic because there's a copyrighted character that was made by a human that's in it. So you've got Disney's copyright, right, in the character design. And if you use that character, you could be liable for copyright infringement to Disney because you've used a copyrighted character. That was created by a human. That's protectable. It's registered. They're able to pursue claims against that. So there may be some third-party content that makes it so that it's not lawful for you to use that material. It doesn't create immunity for all other claims of liability that you got something from somebody who created it with an AI. What it does do is it prevents that creator who used AI to create the system, it prevents the creator who used generative AI from suing you who take their generative AI image and uses it. It prevents them from suing you for copyright infringement because they don't have a copyright in that work that's created with generative AI.
And you don't think Disney would have a very good argument against Google's VO3 model for generating something so close to their IP because the user prompted it?
Right? They might. So there's a separate cause of action by Disney, not by the user of the AI system. So Disney would have a claim against the person who prompted the system to generate that substantially similar output to their copyrighted creation. And Disney might also have a claim against the AI company, Google, for having a system that tends to output that kind of content. It's called vicarious liability or indirect infringement.
It's weird. One of the ways that I sometimes envision large language models or even video models is kind of like compression, like the way you can take a photograph on DSLR and you have like a raw file on your desktop, and then you can sort of right click on it, save it as a JPEG, and now you have a smaller file, which is a compressed version of the real one. There's some data loss, but for the most part, it still looks good and it's a smaller file size. And then you could even zip it again into a zip folder or something. But they're all essentially the same image. Like, I don't feel like you could say like, oh, the zip version is like mine, and then now it's just like when you go from the smaller one back to the bigger one, you make some changes and now all of a sudden it's like your own creativity. But then that system was also trained on what a lot of the final images look like. And I don't know. It seems so confusing to me.
Yeah, I think you're right to be concerned about how these AI models are ingesting the data, because that does matter as a matter of law. It matters if they're making a copy of the work versus just taking tiny little snippets or some interpretation of the work in order to ingest that into the system. That matters as a matter of law. And it also matters as a matter of law whether the outputs are going to be a stormtrooper or some random space alien, right? If you have outputs that are substantially similar to a copyrighted input, that's a separate violation for derivative work infringement.
Yeah, and maybe there'll just be some kind of a prompt where you just say, create a stormtrooper, but like change it just enough that I'm not violating any known copyright laws. And then that's just how this will all play out.
We'll see.
Yeah. Well, we want to be respectful of your time. I do have like maybe just one more question that's kind of been
Sure.
bugging me, but how are you doing in terms of like energy, time?
I'm good.
Okay,
Yeah.
great. This has been so interesting and so informative. So we really appreciate it. I think you're cutting through so much of the myths that the rest of us non law people, we just make up stuff about this is how the law works, and we're
Yeah.
probably wrong. But this is terrific. One thing that I just heard about, but I'm really not getting is, so apparently New York Times has multiple lawsuits with OpenAI. It seems like they really have some issue with them. And one of the more recent ones, they somehow managed to get OpenAI through some court action to not delete the chat logs that we as users have said we want deleted, or we want archived, or well, deleted, not archived, or stuff we didn't want saved. So New York Times comes in and somehow now OpenAI, the stuff that I labeled as for deletion, OpenAI has to keep that. And I'm so confused about that. How's that even, why? How's that even possible?
Yeah. Companies that are involved in lawsuits have an obligation under the ethical rules of those lawsuits to not delete information that may be relevant to the pending lawsuit. So if you've ever worked for a company that got sued, you probably got some letter from HR or from IT that said you are under a data preservation order and your deleted folder is not going to be getting deleted, or please do not put anything in your deleted folder or anything like that. I don't know if you guys have ever seen that when you worked for a company.
No.
But it's common if you work for a large company to get data preservation orders. And that's essentially what's happening here. OpenAI has a data preservation order, and the decision that the court makes in order to issue that kind of requirement, now you can do it on your own. Your attorneys may advise that you do it so that you don't get in trouble with the court later when they show up and say, well, there should be evidence of this, and you said we deleted that. There's no evidence. They'll find against you in that case and say, well, we'll assume that the information that you deleted was not favorable to you. But you can also have a court issue that order saying that explicitly you're not allowed to delete XYZ type of material. And that can happen when that material would be relevant to the case at hand. So one of the issues that New York Times is alleging is that users of ChatGPT are accessing full versions or substantial versions of New York Times articles without having to click through and go to the New York Times page, and they have a paywall on their material. They're essentially alleging, New York Times is alleging, that users are using ChatGPT to evade the paywall on the New York Times website. And so if users have been saying, tell me what New York Times said about XYZ topic, and they're using it as a way to get around the paywall and to access copyrighted content in substantial form, then that's going to be relevant to the lawsuit that New York Times is bringing. So that's why there's this reason why OpenAI has to maintain the user data, because that user data may be relevant to the claims in the pending lawsuit.
Interesting.
But it's also a privacy nightmare. Do you know what I mean? Like, we're using that to be like, I got this sore on my blank, fix me, and now that stuff's all like remembered too.
Yeah. The good news is that they're probably going to make that kind of thing confidential. It's only going to be available in discovery, and they're not going to, say Dylan searched about the sore or whatever. They're going to say 50,000 people searched for this New York Times article and were able to receive 75% of the article. It's not going to be something where your personal data is going to be out there for everybody to access. They typically put those things under attorney's eyes only type orders, where only the attorneys or sometimes only the parties to the cases, if it's a basic confidentiality order, are allowed to access that information. So, maybe New York Times, if they care about it, will be able to tell if you searched for something problematic, but likely they're just going to say, hey, this is going to be limited to the attorneys on the case, and they're only allowed to disclose it in aggregate without personal information. And we may even have to redact that from the public record anyway, so that it's not publicly available.
Yeah, one thing I think about a lot too is that there's so much data on the internet, like photographs that I'm probably in the background of, or we all are at different, people, other people's photos that were geotagged, and there's certain things on different parts of the internet that could all be put together. And I feel like some sort of superhuman AI or something very smart can start piecing together all of our individual histories in a way that's going to be probably another thing that we're not dealing with yet, but there'll be a lot of legal systems that say, hey, like this person probably committed this crime, or this person probably should be punished for this, or is probably did this. And like, then they'll have to go look into it and look at the data, and it's going to like find new things that people have kind of been like under the radar before. And people are going to be like, is that legal? Can you put those things together? Like, should it be anonymized in certain ways? Should data not be remembered forever?
I personally welcome our AI overlords in that context, because I feel like it'll be incredibly useful for rule of law if there's more data on the harm that people do to one another. There are so many instances where people are harmed in ways that people don't believe them. I think, for example, about rape and domestic abuse survivors. And there are so many situations where they're just not believed. And having some sort of data trail to help establish that is, I think, going to be incredibly useful for rule of law and for getting to the right answer, and to avoid the bias that courts and police officers have in situations. You can imagine a situation where, I knew somebody who was arrested after a fight simply because they were darker and bigger than the other people. And if we had had people around them or had some sort of data to say, no, what actually happened was not what your bias assumed happened. And they had an eyewitness, by the way, that testified testified contrary to what happened, but in accordance with bias. And in that situation, the law really gives a lot of weight to eyewitness testimony, which is often flawed. There's many, many studies about how eyewitness data can be essentially tampered with by bias, and that oftentimes even our own memories of a situation reflect our existing biases. If we had data to tell us what actually happened, I think that'd be incredibly valuable. Now, there's also, of course, the privacy implications, right? We don't want to live in a police state where police are finding problems that don't exist, or that wouldn't be a problem, except that it was captured on camera. You think about somebody perhaps using an illegal drug, but they're by themselves and then they walk home or something like that. Nobody's harmed. That would be something where ordinarily police would not conduct an arrest, but perhaps in this kind of world they do, right? So I think perhaps there should be different rules for the police deciding to arrest somebody on the basis of that, versus people being allowed to use it for defense or for proof of something where the arrest or the civil violation was filed on the basis of something legitimate and not sort of this privacy invading type feeling. But I think it's a delicate balance.
Or just like, I'm a little worried about just lawyers being like, I need some more work. Like, find me something that I could litigate right now. And AI is like, oh, like, I think you could sue this company or these people or something like
Maybe for
that,
the best, though, right? Don't you think that may be for the best? Because it can also really help to establish that wrongs happened, right? I think about toxic torts or injuries from products. And AI can be really useful for helping to show patterns that existed in a data set that may not be something that a lawyer would otherwise uncover without significant investment.
My first examples in my head were just like, I don't like that guy on the internet. Let me type in his name and do something to him.
Yeah.
Or like those people are politically different than me. Like, I have a ton of money, like screw them. But you're right. If it's used just to even out things that have been going under the radar. Like I just read about an AI that uncovered $14 billion in healthcare fraud that the DOJ just released their whole like system of how the AI sort of figured out where the money was being funneled out of the country for these like fake catheters or something. And I was like, okay, that's a great use of money, but
Yeah.
could turn on us too. So I don't know.
I think we have to establish systems of government and policing that are conscious of the policy implications, the privacy implications, but also balancing and weighing positively the benefits of having more evidence to show that harm occurred or to show that people were injured. And especially when that's a group that's not commonly believed or something like that, or you have, I think not the big ones I really think of are victims of assault and abuse, where it can be really difficult to establish that, but perhaps through things like AI analysis of text message patterns or AI analysis of comings and goings or of how somebody looked at a certain time or not, that you may be able to determine or have some sort of evidence to help support that happened. I think that could be really useful. And the other one, I think lawsuits against big companies. I think of products that contain dangerous chemicals. And if the AI is able to look through medical records of a vast swath of people and able to show that all of these people purchased this item at this store around this time period, and then a year later they're coming to their doctor's office complaining about this or that can be used to help show a pattern that otherwise never would have arisen. And you mentioned for determining financial fraud, it's incredibly difficult and costly for human experts to go through and trace money to determine financial fraud, but AI can be incredibly good. And algorithms can be incredibly good for trying to identify financial fraud as well. So I think there's a lot of good potential. I'm on the optimistic side as to how AI can be used. I would want to set out some sort of framework that says, for example, there's some sort of Fourth Amendment protection against the police going and hunting for violations by, searching all the cameras to see, who took a puff of something that wasn't a cigarette and then walked home or whatever, right? We don't want police using this as a basis to file a new claim that they otherwise wouldn't have been able to bring.
Well, yeah, and to me, it seems like as long as if a regular person who signs up for ChatGPT does a query and a prompt and it gets stored on the server forever and it can be analyzed, then there shouldn't be like a government ChatGPT where you can ask questions of it and there is no record or something private, because then I don't know if the police search, like, find all the people who are of a certain political party and then find me evidence why I can go after them, versus like I need an AI that can look at that system too and verify that they didn't ask any questions like that to get to the conclusions. So I just hope for transparency on both sides, and then it seems like
there
you'll
are
have
protections. There are protections already in place that stop police from getting access to the same kinds of things that the company can get access to. The police can't, for example, go to Facebook and say, I need you to perform this analysis and identify every person who may have committed this or that violent act based on the videos that they've posted to Facebook. But what the police can do is search public posts and identify some conduct that may be supportive of some kind of claim against somebody, or to help establish that somebody committed a crime that has an outstanding warrant or something like that. But there's currently restrictions on the ability of law enforcement to get the data that's at a private company without a warrant for obtaining that data. They have to have a justification in order to force the company to hand over your data.
Yeah, like every version of the future I can imagine seems safer because of surveillance and also just less privacy. So, I mean, it does seem like it's going to be hard to get away with anything. And a lot of things that people have gotten away with will come back together, back to haunt them. So,
yeah, I agree. I think you get more moral behavior the more that people believe that there will be consequences and proof of the harm that they've engaged in.
Well, think of how powerful it was just knowing that like Santa Claus was watching you all year,
Yeah.
and like, I need my present, but now you can actually say like, it's not Santa Claus, it's OpenAI, and like they really are watching everything.
Yeah, I think there's a lot of people that justifiably have a very different position than I do on this and would say, no, we need to have privacy. We can't have any of this business where companies or governments, especially, are looking into our personal data because I have my privacy and I want to be able to do things that I don't believe this, but that I want to be able to do things, they might say, that violate the law, as long as they can't bring a claim against me because they don't have a basis for arrest, right? But personally, my belief is that I'd rather live in a state that has less privacy and more protections and more ability to prove harm.
Yeah, it's such a difficult question to answer because it's like as long as you trust that the people that are setting the laws and enforcing the laws, as long as there's some trust there, there's so much good that we can do with AI. But the second you start thinking like there could be people that are corrupt or biased or just looking to gain power, all of a sudden like all this stuff gets so scary, and it's very hard to know which way it's going to go. But I agree with you. It could have just incredible benefits for the law, for safety, for everything. So hope.
I think the line needs to be that government actors are not able to conduct searches of that data without a warrant, but that in a civil lawsuit, entities could request that data as part of civil discovery. That's where I think the line should be.
Interesting. Okay. Any other big things that we haven't covered that is important for people to know? Any myths that you want to dispel or anything like that?
You mentioned in your initial email deepfakes.
Mm-hmm.
I think deepfakes is important to talk about. The one bit that I would highlight is that we now have a federal law that covers some aspects of deepfakes.
Okay.
We have in May, the president signed into law the Take It Down Act, which prohibits the distribution of non-consensual pornography, whether that is actual images or digital replicas of that person. That's what they call it, or deepfakes. So it essentially prevents the Taylor Swift problem, where Taylor Swift had her likeness used to create non-consensual digital deepfake pornography. And she did not want that, but there was no federal law to protect her. And many states do not have protections against digital depictions of non-consensual intimate imagery. And so the new federal law prohibits both actual and digital or deepfake non-consensual intimate imagery or non-consensual pornography.
So this is mainly a tool to take it down from the internet, not necessarily something that's going to open people up to liability. It's just like we don't want it up there, so we take it down, right?
It's
Or does it
both.
allow you
So,
to attack the person who did it in the first place to deter the behavior in the first place?
yes, so it's both a criminal violation that can be pursued by the government. And so if you're victimized by a situation like that, you can push for prosecution at your local attorney's office, your local government attorney's office, and you can try to push them to prosecute and get a criminal charge against the person that did that to you. In addition, you can get it taken down from online platforms by requesting a takedown of the content under this law on any online platform where the image appears. The online platforms have an obligation to remove the content within 48 hours. There's a lot of scholars that disagree that the 48-hour period is sufficient or appropriate. They say that it's going to lead to widespread over-tagging of things as a violation of this act, simply to get it removed at important times. You could imagine if somebody has a political image that is unfortunate for some political candidate, that the political candidate may say that they want it taken down, and the platform won't have much time to engage in human review, and so they just take it down. That's what will probably happen in a lot of situations. There's going to be a lot of abuse there. But I think it will also result in a lot of benefits for individuals whose images are used for non-consensual pornography as well. But I think one of the articles that was discussing it said that shortly after it was passed, Trump said that he was going to use it to take down some things that he didn't like. I think the article mentioned a photo of Trump like kissing Musk's feet or something like that. And so if you just flag something like that you don't like as being a violation of the act, the platform is likely to just take it down. That could lead to definitely overextensive takedowns.
Right. And so this is basically anybody that appears in the image can request that. So I remember a while back there was Gawker, and they posted some private videos of, I'm blanking on the guy's name, the ex-wrestler, and apparently Peter Thiel was also involved somehow in the lawsuit to take him down. So what were the laws prior to this? There was just no protections, or how did that work?
It was a state-by-state protection. So some states, it's very limited, but some states like Virginia, for example, has a non-consensual pornography law that says that it is unlawful to disseminate intimate imagery of another person, typically something that depicts genitals or something like that, of another person without their consent. There are a few other states that have laws that prevent that, but very few states would have coverage that extends to deepfake images. You can probably read some of the things like the Virginia law to extend to deepfake images, but we don't really have case law that talks about that very much. So it would be a state-by-state enforcement. Many states don't have any laws at all to protect against non-consensual pornography, let alone ones that are digital depictions. So it's an area that I think probably was ripe for having a federal law, but a lot of scholars disagree about the implementation of having this 48-hour takedown, which they think could be abused, perhaps even more so than the abuses of the copyright takedown system under the Digital Millennium Copyright Act. But personally, I think that it's helpful to have a takedown system. I proposed many years ago when AI was first being used for deepfakes. I think I wrote this back in 2021 or 2022. I wrote an article talking about the need to have a takedown and removal statute for deepfakes, and specifically for deepfake pornography. So I'm personally glad that they did this. I think it's going to help a lot of people. And having a federal law is going to be much easier than handling all of this through state-by-state enforcement. But a lot of scholars have disagreement.
Last week, I saw articles coming in saying that, kind of like coming through my feed, that said Denmark is tackling deepfakes by giving people copyright to their own features, their own faces. Is that pretty much the same thing in different terms, or does the average American have a copyright on our face?
So there's a different law that applies called the right of publicity. And I've also proposed that we have a federal right of publicity. Right now, this is governed by state law as well, and state laws differ. They differ in many ways, including whether you can maintain your right to your image after you die, whether that passes to your heirs. There's a lot of conflict from state to state as to how this right applies, but it's called the right of publicity, and it protects against somebody else using your name, image, or likeness in a commercial misappropriation. So it has to be something that's in an advertisement or something making money for the person who's using it. If somebody just uses your image or your likeness to make something for entertainment or to abuse or harass you, that's not a commercial use, and so it wouldn't violate any state laws. You may be able to bring some kind of claims for, emotional distress or libel or defamation, but they're so hard. It's so hard to bring something like that. And if you're just depicting somebody doing something that they don't like, you may have a false light claim. That's a tort claim for saying somebody is something that they're not. So if you depict somebody having HIV, for example, and they don't have HIV, that was one of the cases. where there was a claim for false light. You can have that, but it's really, really hard when it comes to intimate imagery. It's hard to say that that's false light, right? I mean, if you have a deep fake of somebody engaging in a sexual act, it's hard to say, oh, that's false light. Many people engage in sexual acts, so it's not false light, right? So it's not a situation where you're depicting somebody doing something that they don't do, right? It's not a false light. So, depending on how extreme it is or whatever, but it's an area where most state laws just don't protect against that. So I do think we need a federal right of publicity claim. We don't currently have that, but this act that relates to non-consensual pornography is a first step towards that it addresses the most egregious and the most common uses of deepfakes. Deepfakes, about 95% of them, I believe one recent study concluded, deepfakes online are primarily used for the generation of pornography. So as many things on the internet are. And so it's an area where I'm glad that they focused the first statute on this issue, but we still have more to address here. I think addressing deepfake use of actors, images, and likeness is going to be important coming up soon as well, because it may be the case that you can cast an actor in your movie without ever getting their consent, if depending upon whether this is a commercial use or non-commercial use or something like that. It may be hard to establish commercial misappropriation under the state laws. This is going to be particularly true for actors that have passed away, where under many state laws, their heirs don't have any rights to assert a violation. So if you have an actor that passed away in a state that doesn't have postmortem right of publicity, then that actor's likeness could, under current law, simply be used in a movie without their consent or any compensation to their heirs. I view that as problematic and in need of a federal law.
Yeah, it's going to be so interesting too, because it's like, where do you draw the line in terms of similarity? We saw OpenAI, Sam Altman, release an AI voice. So he said, oh, we're going to have the assistant like in the movie Her, right, played by Scarlett Johansson. Then he releases a voice that a lot of people say, oh, that's obviously, her, that's her voice. It wasn't, if you listen side by side, it's not like 100%, but you can definitely hear the similarities. We also have, as you're saying, I remembered in Tiger King, if you guys remember that from a few years ago, where he had the competitor whose husband went missing. And at some point, he shows a video of her feeding what seems to be human remains to the tigers. And the lady that he used was exactly looking like the competitor. I know he found somebody that looks exactly alike. So that's going to be kind of hard to figure out. Is this this person that I'm looking at, if it's a deep fake, or is it somebody else? I mean, it might be obvious in certain situations, but it's like if you just move it slightly away from that. Do you know what I mean? Is there any way that we think about that?
Yeah, I have a blog post up on the Scarlett Johansson OpenAI dispute up on my website. I don't have a ton of blog posts there, but there's one there. I might have a YouTube video on it as well. But in the Scarlett Johansson and OpenAI example, that was a situation where she does have a right of publicity claim in her voice because her voice is recognizable. It's a way that people can identify her, and she's used that commercially. So under most state laws, her voice is going to be protectable under the right of publicity laws. So then you have a company, and they're making use of a voice that other people will recognize as being associated with her, both from her and her Scarlett Johansson. So if you have a voice that the public believes to be Scarlett Johansson, and it's used in a commercial context, meaning for a paid service, then that's a very, very clear right of publicity violation under pretty much every state law that I can think of. You have a living person whose identifiable likeness, including their voice, is being used commercially without their consent. So clear violation. And then we have the added complexity there where OpenAI asked for her permission a few days before the thing was released, and she said no. And so when you have somebody clearly saying no, and they're already far enough along in development that they think this is going to be a problem, I think that creates a huge amount of legal risk. So I believe they ended up deciding not to use that voice going forward because they didn't have her permission and because the voice sounded a lot like her, even though they later said that it wasn't actually trained on her voice, but on somebody that sounds like her.
Mm-hmm.
But case law has found that the use of sound-alikes for purpose of leading the public to believe that this is their voice is a commercial misappropriation that violates right of publicity law as well.
Okay.
So this was a clear case. If they had continued, if OpenAI had used that voice, it would have been cut and dry.
Okay, so sound-alikes and lookalikes, even though it's could be another actual human being, it's still considered if the person that they're trying to look like or sound like is well enough known to where the public might think that that's supposed to be them. Okay, that's
Yeah, and it doesn't even have to be a human.
Right.
It could be a robot that looks like the person. That was also an interesting example in one of the cases. You can have a robot look-alike or a robot sound alike. This will come up a lot in the context of Suno. I think we'll see some cases where if people are making songs that sound like a particular artist, that's going to be really, really clear right of publicity violations of those artists that the user who created that output and likely Suno as well could potentially be liable for those right of publicity violations if it's used commercially. I think we'll need a federal statute that in my mind, the federal statute should not require commercial misappropriation to form the basis of liability, maybe for damages. But I think that we should have a federal law that says anytime that you use somebody's name, image, likeness, anything that identifies them without their consent, that's going to be a violation of that federal law. That's what I think we should have.
interesting.
Yeah,
And where's
that makes sense.
just so we understand, where's style play into that? So, like for example, all the Ghibli images that OpenAI was producing on people's requests, or I've heard a few songs that are obviously like Kanye West because people try to reproduce that, but it's not his voice, and it's not him, but the style is unmistakable. The Ghibli images, the style is unmistakable. Is that a copyright issue or no?
I've got a video up on this one
Okay.
too. It's a short, but on the Ghibli one, the generally style is not protectable under copyright law because in order for something to be protectable under copyright law, it needs to be a particular expression. It needs to be an original expression of your creative mind or whatever it is. But if you don't have some expression that's fixed in a tangible medium, like an image or a movie or a character design that you've written down, then it's not going to be protectable. You can't copyright the concept of line art. You can't copyright the concept of even a particular appearance, as long as what the court would do is say, is what you outputted substantially similar to some existing expression. So if you, for example, use if you use ChatGPT to generate a Studio Ghibli style portrait of you, standing there with your cat, which is what I did, it's probably not going to be a problem. But if you dress up as some of the characters in Spirited Away and then you pose like them and then you have that converted, well, that's going to be substantially similar to a copyrighted work. And then you're going to face that copyright liability.
Interesting. So many great questions. It feels like it's going to get so much more complicated figuring all this stuff out, especially because now so many more people can produce this stuff. Do you think our current laws and everything else, do they need to be updated significantly, or we're almost there, or we everything is set up in a way that we're going to be able to get through this without changing anything? Where do you think we're on that scale?
We can get through without changing anything because courts will try to interpret the law to apply to the new situation. That's what they've done for hundreds of years every time a new technology comes out. But it's a lot harder when we don't even have a federal law on the topic. So I think when it comes to creation of deepfakes, that's one where we do need a new law because we don't have a lot of existing laws that would govern that conduct. And there's a harm that's happening that is brand new because of this new technology, a harm that wasn't anticipated before. And when you have some new harm that arises, you may need a new law to cover that. when it comes to the copyright or the patent issues, I don't know that we necessarily need new laws. We can figure it out under existing law, but I do think that when policy implications are extensively coming into play, like the question that a lot of the courts are raising in the copyright and AI training cases, where the courts have been saying we shouldn't be considering the importance of AI to the general public when making these decisions because this is about the parties before us, not the general public. When you have courts really struggling with those questions, I think it would be useful for Congress to step in and say training does not constitute copyright infringement, or training in AI is a defense to copyright infringement unless the original training data was based on pirated data or something like that. That's where I think it would be nice for Congress to provide some clarity. But if they don't, people are going to be fine. Eventually, the Supreme Court's going to settle it. There's just going to be a lot of confusion at the key points of development where a lot of companies are having to invest massive amounts of money in legal risk and putting money aside for that huge legal risk that they could face because it's uncertain what the result is going to be.
Yeah,
We're going to be in that boat for a few years.
Yeah, I can imagine Tesla probably needs to put some money aside too in case robo-taxis or if Waymos end up causing damage. And because I'm sure in some cases, even though you might want to argue over who's like at fault, there is a lot of money flowing in one direction. And I feel like the legal system will kind of follow the money and say, hey, like you made a lot of money in these robo-taxis and they just did some damage. Like somebody's got to be liable here.
Yeah.
Maybe the court system will adapt to that.
Yeah, the downside of courts, though, is that they only impose liability when you have a proven harm, when you can prove the amount of that harm for many types of violations. You know, copyright, thankfully, you don't have to prove the amount of harm. You can rely on statutory damages. But for torts, you're going to have to prove how much did this harm you? Did this actually harm you? Was the person that I'm suing actually responsible for this conduct? Who's responsible? How much responsibility should they bear? And that can lead to a lot of situations where people that were harmed go uncompensated because they're unable to prove or unable to afford to bring a lawsuit. And so if you're trying to rely on the court system to make things fair, that it doesn't make things fair for everybody. It makes things fair for the rare parties that are able to successfully bring a lawsuit and maintain it all the way through trial and all the way through appeal. That's not going to be everybody. So I think if you have something that's going to cause harm for a large group of people, having new regulations or new laws can be useful for trying to protect larger groups and not just protect those who are sued or who are suing.
Yeah. One of the jokes I heard online, I don't know how serious it is, but could be, they're saying one of the new jobs that AI is going to create, they refer to it as like a sin eater. So somebody that's designated as the fault person. So if you're an architect or if an AI system is doing architecture, there's one person that's, if the building falls down, they're at fault. Or in the law system, if they're doing some sort of a law research, there's always need to be a human who's going to be the scapegoat in case things go wrong.
Right.
The AI Jesus.
Yeah. It's like, we're brand new, your minimum wage, but you've been promoted to head of AI at our company. Thank you.
Exactly.
Like, okay.
Director of AI. In case anything goes wrong, you're liable. So I don't know.
Most of the time, companies have they'll have director and CEO and C-suite insurance that are going to cover liabilities that would otherwise be directed to that individual. And so ultimately, the liabilities that are as a result of the actions of a company are going to be borne by that company and unlikely to be borne by those directors and officers.
That's interesting. So there might be a whole new industry, is like a very specific insurance type for insuring the issues that could arise with using AI automated systems. That could be a brand new sort of thing that arises.
Yeah, I'd be very curious to see what the director and liability insurance looks like for Tesla, for example. I imagine they pay a lot in liability insurance.
Yeah, that's like a whole new thing. So, well, this has been absolutely incredible. I think this is our longest interview ever. Thank you so much for taking
thanks
the
for
time.
hanging out with us.
This has been
Absolutely.
so incredible, so illuminating. Thank you so much. And I think we barely scratched the surface of all the topics that we can talk about. So if you ever want to come back and do another 2.5 hours,
Happy to.
more than welcome to. So thank you so much. And we'll leave all the links to the various blog posts, your paper that you've published recently, you said, and as well as your YouTube channel. So everybody, please check it out. It's incredibly informative, and there's so much that we haven't even touched on. And let us know in the comments if you want us to have her back again to talk about and also what other questions would you want us to cover next time. So thank you so much.